this video, I'm going to walk you through exactly how to move real estate into a revocable living trust the right way, without triggering lender issues, without tax surprises, and without losing control. Let's get into it. You own rental property, a vacation home, or a development parcel, and you know somewhere in the back of your mind that if something happens to you, your family is about to walk into a courthouse. You've heard a living trust can fix that, but every time you start looking into it, you hit the same wall. Deed language, lender consent, title insurance, and the fear that you'll accidentally trigger a tax event just by moving a property. And here's the problem. If you don't get this right, your real estate doesn't pass to your heirs cleanly. It gets tied up in probate, exposed on public records, potentially stuck in a lawsuit before anyone can touch it. So you can eliminate probate exposure, keep your properties private where the laws allow, and make sure someone you trust can step in immediately if you ever are incapacitated. I'm John Conrad, forensic accountant and founder of Numeratus.us. We're the white glove concierge accounting firm for ambitious startups, entrepreneurs, and high net worth clients. We cut through the complexity and help you safely navigate business and wealth protection in the 21st century. Let's start with the mistake I most often see. Successful real estate investors, people with 5, 10, 20 properties, still hold title in their personal name or in a single basic LLC that they control directly. When you hold real estate in your personal name, every property is tied to you in the public record. That means anyone with a judgment, a grudge, or a data broker subscription can map your holdings in about 10 minutes. More importantly, when you die, those properties do not pass automatically to your heirs. They go through probate. That means court filings, delays, legal fees, and in many cases, forced sales or family disputes. Even a simple LLC doesn't fully solve this if you're the sole member and the operating agreement is weak. A creditor can still get to your membership interest in the wrong state, and your heirs still don't have the clean transfer mechanism. The real cost isn't the annual filing fee. The real cost is what your family pays in time, money, and stress when they're already dealing with your death or incapacity. That's the first thing to understand here. Holding investment real estate in your personal name is the single most common probate and lawsuit exposure among successful real estate investors. And a properly funded revocable trust is the cleanest way to remove that exposure while keeping full control. How do you actually move a property into a revocable living trust without creating new problems? The key word is funding, and most people misunderstand what that means. Funding the trust means changing title on the deed. You sign and record a new deed that transfers the property from you as an individual to you as trustee of your living revocable trust. In most cases, this is not a sale. It's a transfer to a trust you still control. For tax purposes, a revocable living trust is typically a grantor trust. That means the IRS ignores it as a separate entity. You still report rental income, depreciation, and capital gains on your personal 1040 exactly the way you always have. There is usually no new tax return required just because the property is now titled in the trust. The bigger concern is your lender. Many residential mortgages have a due on sale clause that say that the loan can be called due if you transfer the property. The good news is that federal law generally exempts transfers into a revocable living trust where the borrower remains the beneficiary and occupies the property. For investment properties, you need to read the loan documents carefully and sometimes get written consent. Title insurance is another tripwire. Some title companies will refuse to insure a property once it's moved into a trust unless the transfer is done correctly and the policy is updated. The deed language matters here. Quitclaim, warranty, and grant deed language each carry different implications. So the second takeaway is this. Funding a revocable living trust is usually a non-taxable title change, but you have to coordinate the deed language, the lender, and the title insurer before you record anything, because the recording is the easy part. The relationships are what trip people up. If you're watching this and realizing your properties are still titled in your personal name, that's not a failure. That's just where most people start. At Numeratus.us, we work with you to verify that the funding happened, that the tax reporting stays consistent, and that your books reflect trust-owned rentals cleanly. If you want a second set of eyes on your structure, a link to book a consultation is in the description below. One of the biggest reasons people use a living revocable trust is control, not just while they're alive, but after they're gone. And that control depends on how well the trust coordinates with everything else in your estate plan. When you move real estate into a revocable trust, the trust becomes the owner of record. In many counties, that means your personal name disappears from the property records and is replaced by the name of your trust. That alone cuts down on a lot of casual exposure. But privacy has limits. A revocable trust does not hide assets from the IRS. from creditors in most cases, or from a court that has legitimate jurisdiction. What it does do is it makes it harder for random people to connect your properties to you, your family, and to your other holdings. The pour-over will is the backup document. It says that anything you forgot to put into the trust during your lifetime gets poured over into the trust after your death. This is critical because an unfunded trust is essentially a worthless piece of paper. I've seen people pay thousands for a beautiful trust document and then leave every asset outside of it. You also need to think about who sees what. Some people name themselves as sole trustee while alive, with a successor trustee named for incapacity or death. Others bring in a co-trustee or a professional trustee earlier. Each choice changes the level of control, privacy, and administrative burden. The third point here is that a revocable trust only works if it's funded and coordinated with your pour-over will. Privacy and control are real benefits, but they depend on the follow-through, not just the document. Most people think about trusts in terms of death. But one of the most practical reasons to use a living revocable trust is incapacity. What happens if you're alive but unable to manage your affairs? If you own real estate in your personal name and you become incapacitated, someone has to go to court to get authority to manage your property. That could be a spouse, an adult child, or a professional guardian. Either way, it's public, it's slow, and it's expensive. With a properly funded revocable trust, your successor trustee can step in immediately. They can collect rent, pay the mortgage, handle maintenance, and make decisions about refinancing or sales, all without a court order, as long as the trust document gives them that authority. Probate exposure also varies dramatically by state. In some states, probate is relatively fast and inexpensive. In others, like California, Florida, and New York, probate can take a year or more and eat up a meaningful percentage of the estate. If you own property in multiple states, your heirs may face ancillary probate in every state where you hold title personally. A revocable trust can own property in any state. That means your successor trustee can manage a nationwide portfolio under one document, and the family can avoid multiple probate proceedings. So the fourth takeaway is that a revocable trust is as much an incapacity tool as it is a death tool. And if you own property in high probate or multiple states, the trust becomes even more valuable. Here's where most trust plans quietly fall apart. People set up the trust, fund it once, and then never look back at it again. Meanwhile, they buy new properties, refinance old ones, or change insurances, and the trust gets out of sync with reality. Every time you acquire a new property, the default should be, does this go into my trust? If it doesn't, you need a reason why. Maybe it's a short-term flip. Maybe it's a commercial property with different lender requirements. But the decision should be intentional, not accidental. Refinancing is another common trap. When you refinance a trust-owned property, the lender often requires you to take the property out of the trust temporarily to close the loan. After closing, you have to remember to put it back in. A surprising number of people forget this step. Insurance also needs to match. If the property is owned by the trust, the name insured on that property and liability policies should reflect that. If your policy still names you personally and a claim gets denied because of the owner of record is the trust, that's a problem you could have avoided. At Numeratus, we do annual structure reviews of our clients. We look at deed records, the entity chart, the tax returns, and the books. And we ask one question: is everything still properly titled? That single review catches more problems than any other steps in the process. The final point is that the trust is not a one-and-done project. It's a living structure. It's a living entity that has to be reviewed every year, especially after acquisitions, refinances, or any other major life change. If this video helps you see the gaps in your current structure, the next step is simple. Get a qualified estate attorney involved and make sure your accountant knows how to keep your books and tax reporting clean after the funding. Or at Numeratus.us, we can do both for you at a fraction of the price a CPA and a lawyer would charge. We act as the long-term structure auditor, trust builder, and tax accountant, reviewing trust documents annually for funding gaps, distribution compliance, and tax efficiency. If you want help making sure your real estate is actually protected, book a call through the link below. Thanks for watching, and I'll see you in the next one.